Sir, sir, DNR, sir. Sir, thank you, sir.
Thank you, sir.
So one photograph all together. Thank you.
Mahendra Kumar Bajpayee, Advocate. Done? Sir, yours.
Dr. Shantha, Senior Consultant Diabetologist, Apollo Hospitals, and former Vice Chancellor, Tamil Nadu Dr. MGR Medical University.
Dr. Ravi Shankar, Medical Legal Consultant, Family Practitioner, Chennai.
Sir, wait, sir. Sir, wait for 2 seconds. After
Dr. Ruben, professor in a private dental college, as well as a practicing dentist, and interest with medical legal aspects in dentistry.
just look at the camera for 2 minutes.
Dr. Vivek Madi, gynecologist, done my law and specialized in consumer law and cyber forensic from National Law School.
Dr. Arunachalam, family physician.
Dr. Nirmal Frederick, ophthalmologist and principal assessor NABH.
Dr. Ashokan, CEO, Gem Hospitals, Chennai.
Dr. Nandakishore, Head of Department, Anesthesia and Surgical Intensive Care, MGM Health City.
Dr. Balaji Pillai, Vice President Operations, Clinical Globals Hospital, Chennai.
Start. Ravi will start. Dear friends, welcome to this 4th National Convention on Medicine and Law. Dear friends, welcome to this 4th National Convention on Medicine and Law. This session of this convention is very special, and special in 2 ways. The first one is that we are not going to discuss or deliberate a topic that is relating to medicine per se, but a topic that is more legal in nature, but affects medicine like nothing else does today. Friends, July 2018, and Dr. Ravi Shankar is here, he may correct me. IMA National came out with a national survey that 82% doctors in this country are stressed because of violence, and obviously legal proceedings, the threat of legal proceedings which they face. This Consumer Protection Act, it was enacted way back in 1986. But only after 1996, when the Supreme Court of India gave the judgment in VP Shantha's case, spate of litigation against doctors. I distinctly remember that the Indian Medical Association has raised this point while arguing that matter. That, sir, if you are going to permit doctors to be sued under the Consumer Protection Act, it will not be good for healthcare, and they will not be able to provide appropriate services. In fact, in the judgment, the Supreme Court has rejected this argument. Later on in 2005, in another case, where the Supreme Court has given wonderful protection to the doctor community from criminal proceedings, the Jacob Matthews case. In that case, the Supreme Court has taken cognizance that, hey, look, in 1996, we brought doctors under the ambit of the Consumer Protection Act. But today what is happening, that is not good for the healthcare. A doctor with shaking hands, trembling hands, he will not be able to give proper health care. The Supreme Court did come to that conclusion. Friends, there could never have been a more appropriate time to discuss Consumer Protection Act than today. Reason? Deliberation about the new Consumer Protection Act are still on. The act has been passed, but obviously as the rules and regulations keep on coming, the government is still not sure. And this just now Dr. BC Gupta has shared with me. Yesterday he was there with the chairperson of the National Consumer Commission, Justice Agarwal, a retired Supreme Court judge. He heads the National Consumer Commission, and he told him that we are still deliberating. We have still not come to a final conclusion. The short point for consideration is whether Consumer Protection Act, the way it is applied today in healthcare, is enough to protect the patient, to take care of the negligence, errors committed by doctors, or not? And if not, what other alternative is there? In my opening remarks, I had shared with you that there are two reasons why we should be happy. The second reason why we should be happy is that today in this convention there are two persons. One, Dr. T.N. Ravishankar. Second, Dr. B.C. Gupta, who is going to chair the session. Dr. T.N. Ravishankar obviously is the convener of this entire convention, not only this session. Distinctly remember, way back in 2001, it was Dr. Ravishankar who was saying that Consumer Protection Act must be done away with. He had an alternative in medical tribunal. Good, bad, ugly, that is what he has been campaigning, he has been canvassing for the last 19 years. Dr. B.C. Gupta, he was ex-Home Secretary of Punjab State. He is the first person in this country who had piloted an act, not Tamil Nadu, to protect doctors. Punjab was the first state in India which had brought a law to protect doctors. And he is an authority. He was obviously there on the National Consumer Commission. Many of the judgments that you would be reading, he was the author of those judgments. So not only does he have an exposure, experience in courts, but even when he was there as the Home Secretary of Punjab State, he had piloted that bill. which later on became an act. After that, he became the Secretary for Labour, Government of India. And there he was felicitated by, I think, International Labour Organization for mediation and conciliation. That is something on which he has an expertise. So with these two illuminaries here, at an appropriate time, friends, let us discuss this aspect, whether Consumer Protection Act is providing benefits to all sectors of society. Let us not be partisan. We are doctors, fair enough. But whether this act is protecting doctors, is protecting patients, yes or no, and if no, or if yes, whether there can be an alternative. And what can be the alternative? Friends, what I propose to do, subject to everyone here agreeing, is that each one of us will speak on this topic. Ravi, if you have to leave.
No, I am here.
Okay. Each one of us will speak for 3 minutes. One, whether Consumer Protection Act has been able to deliver what it was meant to deliver, especially in healthcare. And number two, if not, what are the alternatives? Okay, can we start from there?
Yes, good morning, and thanks for the introduction, and I think opening up the very important and a crucial convention for today's. The need of the hour is, yes, now there is a big drift between the patients and the medical fraternity. And everyone, I think, would also recognize or copy me when I say that, yes, Consumer Protection Act or the Consumer Forum that has come in has divided these two groups or these two communities to a bigger extent. To my knowledge and to my observation, what I have seen is there have been very few instances where it has done good for the society and it has got, but on the other larger extent, it has done more divide and created more confusion amongst the public. So this is where we feel that there is a need for an alternate forum or an alternate platform where we can bring back the glory of medical practice. Once upon a time when in India, like we were talking about, all the doctors were trusted next to God. Because those days, the patients or the society at large was not looked at as a consumer. The word consumer protection itself made these patients, whether they are knowledgeable, not knowledgeable, the society around them, the relatives around them, they are the ones who can say, yes, if something is gone wrong with partial knowledge or with no knowledge, they can always tell them or misguide them, saying that they can approach the consumer protection. So this is where we feel that today it is we, the doctors and the society put together, we need to come up with an alternative, saying that yes, we need something better than the Consumer Protection Act.
What is the alternative according to you?
The alternative to me is, I think we should have a medical tribunal wherein we would have, there are so many doctors, as we say that one of the doctor who's already got himself educated and qualified as a legal person. I think that's from the national law. So similarly, I think there's time for us. Now many of the doctors have now groomed themselves to be good administrators in the corporate hospitals or in the private hospitals. Likewise, now is a time for the doctors to also get themselves educated on the national law, wherein they will know what is the provision for the doctors? What is the right frame of the constitution that they can play within, and not only secure the safety of the patients as well as the medical fraternity?
Thank you for inviting me into this convocation. It's an excellent opportunity to interact and gain knowledge also. So, just to give you a background, I've been working in the UK for around 10 years and as a consultant as well. So, I've seen how this is being implemented there also. So, maybe I'll just share my experience in that way. First of all, I think branding patient as a consumer is wrong, because in a consumer thing you have definite outcomes. Here it is not so definite. 2 plus 2 doesn't always work out as 4 here. So there can be varied outcomes, there can be varied ways of doing things. So hence you can't justify saying that he is a consumer, he's come with all patients who come to us want to have a good outcome, but we can't always guarantee that. So the focus should be on, have we made adequate efforts or decent efforts to standardize the treatment. So definitely Consumer Protection Act is not for this profession, and what it has done to me, having looked at both sides of the Western world and here, is it has only evolved what is we call as defensive medicine. So now what people are starting to do is, because they are afraid that he might sue us or he might later on put a case against me. So what we are practicing is defensive medicine. That is leading to doing unnecessary investigations, unnecessary procedures, giving them a lot of negative information, which in turn takes away the trust from the patients as well. So this has in both ways affected the practice we do, as well as the mutual understanding and the trust that we had, the patient and the doctor had. So in both ways it has affected. So this definitely has to stop for the profession to evolve. As an alternative, what should we think? I think it's not just only from the legal side. There is a lot of effort need to be put from the medical side as well. First of all, I think we have to divide standards of care. So in UK, just for example, what happens is, for everything you have a standard of care in which there might be, if you apply these things, what we call as protocols, there might be 5 to 10% of patients who will miss the radar and have bad outcome. But as long as you applied these standards and applied these protocols, you've done what is best for the patients. So those sort of standards have to be developed first. And once we develop that, I mean, it can be done in various levels. It can be done at an institution level to start with, and then at a state level, then at a national level. IMA can help with that. And once these standards are set, and it makes it so much easier for us to practice. We say, okay, I followed these guidelines, I followed these protocols. In spite of it, if it happens, yes, these are the minimum things. Beyond that, I can do what is up to my expertise and what capacity I have. But these minimum things should be practiced. And I can tell patients, this is the minimum thing that needs to be done. And we'll see beyond that, we are doing so many things. And when you are also safeguarded, that when you go to a court or some mishap happens, you say, I've practiced the minimum standards, and in spite of it, the outcome has been bad. So I am protected. In that way, you develop the trust straight away at the patient. Everywhere you go, they know this is what they would expect. And so that will be the first step. Standardization of care. At probably institutional level, it's much easier. So maybe a recommendation to start with saying that every institute that practices should have a standard guidelines of care for every major illnesses. And then that you share with the patient, and beyond that you take it forward at national level and things like that. And this improves the communication, this improves the documentation, and this also takes away the fear in the doctor that if he does this, yes, they won't be questioned. And the third thing is, whenever there's a case, it should be approached by experts. A group of experts who are knowledgeable in this field, in that particular field, should be selected and kept ready so that the court consults them. What we call in the UK is a coroner who has medical knowledge, and he gets an opinion from a tribunal or a group of experts. For example, I practice anesthesia and intensive care. There will be 2 or 3 intensive care specialists along with the physician, along with a public person, who a neutral observer, to see if things are being done right. So involving a public person of good stature in a part of this medical tribunal goes a long way in giving confidence to the patient as well. So this is something probably we can look at. It won't happen immediately, but if we look at in the right direction, probably this is an established way which has worked well in the Western country. We should also look into that as well.
Please, sir, if you can look at the video. Okay. It's very important. Okay. See, the whole point is, after these deliberations today, it is these videos which will remain there on the social media, on other aspects, that we intend to show to the parliamentarians and all. This is what was discussed. It is not that a group of 2 people have come and they are speaking something like this. This is the importance, nothing beyond that. Right. Yeah.
Consumer Protection Act essentially was designed to take care of the consumer's interest whenever there has been some deficiency in the goods delivered or services rendered. Unfortunately, this has put medical treatment also as a service, which can be, like Dr. Nandakishore said, which can be quantified, which can be measurable, and this is not possible all the time because of the nuances of the science per se. The medical council says, it dictates as per the ethics, I should not guarantee a treatment, guarantee an outcome of a treatment. That is what the medical council says. The Consumer Protection Act says that you have guaranteed something and you have not delivered. There is a conflict in this. Any body, any organization that can understand the nuances of medical sciences and that can have a mechanism which is the remedial measures are inbuilt, taking into account of the nuances, is welcome. And definitely the Consumer Protection Act, which has commoditized the healthcare delivery itself. It's not good for the medical profession. One, that medical services have to come out of the Consumer Protection Act ambit. The alternative mechanism. There have been any number of acts and rules, but in the wrong person's hands, they have been very unproductive. The composition of the streams of various walks of life, from where the personnel are going to be taken into the tribunal or whatever we call it as, it's very, very important that at that point we have to be very careful. As a parallel, what I can say is, apart from the General Medical Council, in UK they have had the Medical Practitioners Tribunal Services, a body which is something which we are maybe similar to what we have been talking to. I went through the statistics of last few years. About 30% of the cases that have been brought to this tribunal services have been convicted, either in the form of suspension, or few of them have had erasures and strictures, all those things. So the society and the lawmakers need not be worried that the tribunal, which may be filled with medical practitioners, will be very soft, will have a soft approach to the doctors, and it will not be that deterrent for crimes or errors or deficiencies in services. So I think a tribunal which understands the nuances of the science and it has inbuilt mechanisms to tackle it is the need of the hour. That should be the right alternative for the CPA.
Thank you for the opportunity, and my few inputs on this matter. The CPA at this level, and I think it's been almost more than a decade of Consumer Protection Act. So what is the outcome, whether it has satisfied the law enacted, and what are the risk benefit? So there are two parties here, one the practitioner, medical practitioner, the second one is the public at large, who are the recipient of service. Have they benefited these two core people? I think from the doctor's point of view, one, it has increased the defensive practice, it has instilled a fear among the practitioners. So that does lead to a lot of risk assessment from the practitioner point of view. Because of the high risk involved with a high rising cost, documentation, doctors are not taking up complicated cases. So this actually has reduced the service to the public at large. The second thing is the cost. Because of the accreditation requirements, because of the legal requirement, the cost has risen up. And in the last 10 years, the cost has increased to the medical professionals, to the care providers, as well as to the public by at least 15 to 20%. So if you see all these parameters, the defensive practice, the raising costs, and reduce the risk potential to the medical professionals, the increased potential to the medical professionals and high risk to the patient community. The CPA has failed in all aspect. It has not given the intended benefit. So what is the alternative? People have a negative mindset that if it is filled with only with medical professionals, the law may not give the intended benefit to the consumers, that is the patient. So one thing said about the British Tribunal, and if you go through that, the Tribunal has really acted itself in favor of the public in 70% of the cases, where of course the evidence, the objective evidence required for the Tribunal is available. But unfortunately in Indian context, I'm a NABH assessor as well. I've assessed over 150 hospitals. The documentation part is missing, the evidence are missing, and without evidence, how the court or the tribunal can decide in the cases has to be taken care of. People have been talking about the standards being implemented in the hospital. Even though standards are there, NABH has been there for almost 10 years now. It has really improved the documentation and the communication aspect. But still, it has not gone to beyond 10% of the hospital. So we really need government intervention as well as the lawmakers to understand this aspect. So we are in a third world country as far as healthcare country. We can keep saying we have a developed nation in healthcare in spite of being a lot of medical service providers, and our range of service ranges from world class to third class. So 70 to 80% still in the rural urban areas where the standards have not reached. The standards of care cannot be evidenced properly. So we have to focus on an alternative mechanism. Tribunal is a good idea, but it has to be balanced approach. You can't straight away reach Western standards. So we need to approach this step by step. So how to approach this step by step? One is the people who are already in healthcare services, we can train them to be good lawmakers. And so the law should start from the healthcare providers' perspective, and then of course patient benefits and patient point of view, community point of view, as well as government point of view can be implemented in the next phase. So these are all things that has to be taken step by step, and once it is taken, it has to be implemented properly. That's where we fail as a country. We make laws, good laws, but we fail in the implementation stage. And if at all we get through this tribunal stage, and if there is a law coming up, that the implementation mechanism has to be stringent. So this implementation mechanism also has to be part of the law, rather than just proposing the law alone may not count. So that's my few cents.
Good morning, everyone. Thanks for giving me the opportunity. A few words to add upon. Following the introduction of CPA, that is Consumer Protection Act, it is mainly started to just to protect the consumers or to make the doctors having the fear of practicing with the public. First thing. Second thing is, I'm in the field for the past 15 years. I feel it creates a gap between the doctors and the patients, because the doctors are in the fear of handling the patients very much, because in the olden days, whatever I say, the patient will accept. And I don't have a fear of going for the consumer forum. But nowadays, if I'm starting in the practice, whatever words I communicate to the patient, or whatever investigation I ordered for any other illness, I have to think twice, because if I missed some investigations, I had fear that the patient will go for the consumer court. Or if we ordered for some investigations as a defensive format. In the same context also, we have in the fear that patient might sue for because they are asking for the unnecessary investigations. So the cost of the treatment again will be the burden for the public. So the Consumer Protection Act, which we thought as a beneficial to the customers in the form of giving good quality, at the same time it increases the cost of the treatment, which is again putting on the burden for the public, first thing. Second thing is, as sir told, the cost management is raised. Then regarding the Clinical Establishment Act, which is introduced, it holds a lot of formalities to be completed before they start in the clinic. So again, it's a burden for the doctors who are running the small clinics. So it makes the doctors running the small clinics to shut down in the near future, because they have to invest a lot to start the clinic in the small forum. The next thing is, so in the olden days, doctors used to diagnose the illness basically by using their clinical acumen. But now we are in the forum to create the evidences to support our diagnosis in the court of law. For example, if you want to diagnose sinusitis also, the doctors in the current era, they have to go for the CT scan to make sure that they are able to produce the evidences in the court of law. Another thing is, as everyone told about the warranty and guarantee. In the Western world, even for the inanimate objects, they can able to give the replacement warranty in 90 days, as everyone knows. But in our country, even for the inanimate object itself, we are not in a position to ask for the guarantee or warranty. But we are dealing with the human subject which has a lot of biological variations. So it is very difficult for us to expect the expected outcome in all the patients in the equal forum. So we can't expect the doctors to give a positive outcome in all the cases which they are going to treat. So, so it is very difficult for us, the doctors, to give a guarantee of treatment. So if the assured treatment is not achieved, the doctor should not be get penalized by the court of law. Thank you then.
I'm very thankful to the organizers to invite me and to be with you all as a family physician to express myself. I already told factors are two things. Creators only or manufacturers only can have consumers, and we don't create, we don't manufacture, so we cannot be, patients cannot be consumer at all. India is a country now, even now, 113th position in poverty of and lychee eating population, and dies on the night supper and morning they die without any health care provided after 70 years district wise. So in this situation, not every doctor is given the same set of what you call hospital, means scientific invention does not reach the village also. So we are, the city doctor is not at par with our village doctor, is not at par with the city doctor or a corporate setup doctor hospitals. So money decides here everything. Even in the government hospital, setup is not the same. So even you know everything, you cannot do without instrumentations, without every scientific invention reach the last set of medical practitioners cabinet. That alone is the knowledge. So here is a very good disparity among the service providers. Scientific inventions reach the consumer or patient, what you can say. So this disparity, with this disparity, you cannot put the doctor into the same negligence like a driver or whatever profession, other professions are there. The field of playing is different for each one of the doctors wherever they are put in. Second is, I am quite sure a BL can become a Supreme Court judge. But with MBBS, somehow it is misrepresented. I am specially invited to Tamil Nadu Medical Council, where this year so many newspaper judgments came from the Medical Council. So when I went and asked them, why are you publishing them? Then the learned council told, Medical Council told, we here, at least with the science knowledge, whenever we say something, it is taken to the court. So these doctors will not be prosecuted in the court against our judgment. This is what they were telling. In the sense, here something like medical tribunal, in the medical council, when they give a judgment, it is taken with a pinch of salt in the court. That is what they tell. So this is a prelude to the medical tribunal, what I meant to say. And MBBS doctor can attend a delivery in a village setup or in a train, in a flight. But in a hospital, if he does a mistake, he is going to be punished as the hospital institution has not invited a qualified specialist. Like in any specialty, MD, general medicine is considered to be all professional, medical professional who can handle anything, cardiology, neurology, everything, for just 10 years back. Now super specialization come, but that does not disqualify him to do to attend a stroke patient even in a corporate hospital. But judgment came because the hospital did not call a neuro super specialist, that hospital is liable for negligence. This is only a doctor can understand, in my opinion. If a doctor understands how to treat a what you call neurology stroke patient for 20 years, he became fellow of what you call neurology. Except in India, nowhere it is called MCH, MS, every step up qualification. Abroad, it is only 2 years you train in a place, it is called fellowship. And a fellowship who got a fellowship for 2-3 years trained in under a institute, and he has submitted papers and his experience, he is supposed to treat the patient with a qualified fellowship degree. But in India, we have categorized among ourselves into MBBS, MS, MD, MCH and all, so that only a qualified, what you call super specialist can treat the higher end model diseases. So this is not fair in medical parlance. And like honorable judges can be BL. A BL is himself a lawyer, not only a ML, or ML only can become further qualified as to become a Supreme Court judge, in my opinion. If I am wrong, to stand to be corrected. Other than that, as they have told, it is Obama's one. When nation is what you call striving hard to get healthcare industry to thrive on, when we go on investigating just to keep the patient's court cases in back of the mind, the cost is very huge. Even in America, Obama, during his presidency, he requested people to go to family physician so that to cut the cost, where the patient-doctor relations is better. So, and basics of the what you call allopathy stands, means modern medical science stands on the MBBS doctors only, family physicians only. So here I would stress that consumer court is not at all necessary in our setup, and alternative will be medical tribunal, where doctors can be trained as medical laws can be educated for them, and they can be pulled along. Not only that, in a medical tribunal, I would like to suggest in a Gandhian way, Grama Swaraj, what was he told? Citizens of Grama village should decide about what they want. That will be better than the parliament decides, and for the crores of villages what they want, they cannot implement it. So the same way, even a health ministry or health tribunal, everything should have, from a super specialist to a consumer or a patient who is going to use the setup, to be part of it. Not only doctors, so that in the tribunal itself, in the closed door discussion itself, a layman can question and a doctor in the tribunal can answer before the final judgment is coming out, so that the layman also understand it's not in the doctor's hand always. It's not by law we can cure everyone. It's only at last maybe a fate also there. Thank you.
Well, I have to thank the convener to calling me for this forum. What I'm going to talk to you today is the reason why a medical tribunal is so necessary in our space today. First of all, we have to go through the history. Now, we need a law. If we don't have a law, what happens is there's going to be mob violence. And as it is, many places are already facing mob violence. And if the mob violence increases, it's going to ruin the entire profession. So we need to have a very strong law to protect first the hospitals and the doctors from mob violence. And that's my first fear, mob violence. Now, because we need to have a law, along with the law comes the court. And why do you have a court? Because there has to be a procedure to be followed, a procedure of justice for people. Same time when we go through a court, now we have different courts. You have a city civil court, you have a criminal court and a high court. Then these courts, what is the basics of all these courts are to cause harassment and compensation, to decide on what level of compensation. Now, doctors is a very noble profession. We as doctors, we all fall into a very noble profession. Now, if this harassment and compensation comes into the field of hospital administration, it's going to be very, very difficult. So that's why they've decided to have a consumer court to reduce the harassment to the medical profession. And the government has decided to form a consumer court, but the consumer court still haven't decided on capping the compensation level. They have still put doctors in the same level as a medical accident victim, where the compensation is based on the value of life of the victim. Doctors do not charge patients based on the income of the patient. So it's very unfair that the compensation is given according to the value of the life of the victim. So there should be a cap. That's my suggestion. First of all, there should be a cap in compensation level. And compensation should be based on the procedure and not on the value of the victim. That's one thing. Now, we are talking about the courts. Now, the consumer court has been designed to make it a fast-track court. I've told you the other courts, the regular courts, the city civil court, the district courts and all the high courts have been designed primarily to cause harassment. They can call the doctors any number of times to the courts and disrupt the work, and that is not the right way. So that's why I am for a consumer court. But the defect in the consumer court is that the people who are sitting in the bench, the judgment, they are unaware of the technical aspects, the medical technology and the medical terminology that has been utilized, and therefore that is causing injustice in the judgment. That's what I'd say. So therefore, my suggestion is to have a medical tribunal which will comprise of doctors who will decide if there is really a deficiency, and if there is a deficiency, what level of deficiency it has been. Because the level of deficiency would put a cap on the compensation. Sometimes a deficiency could be just a mistake. But then a doctor can't be blamed. And even if the doctor is blamed, is it the hospital is to be blamed or the doctor? There's different levels who has to be blamed. So all that has to be decided not by a consumer court. It has to be decided by a group of professionals, a professional body. So a very strong professional body elected by the people, just like how we have a parliament elected by people, a medical body which is elected by the doctors themselves. They should be able to decide who is going to be penalized, what is the deficiency levels. So a medical tribunal that has been elected by the doctors themselves is the necessity of the day. And from the medical tribunal, you could go to a consumer court, and from the consumer court, you could go to the city civil court, and higher and higher. That's how this thing should proceed to the high court and then Supreme Court. So a medical tribunal comprising of elected representatives of doctors is the need of the hour. And that's my suggestion. Thank you.
for the invite and the forum to provide my views. The medical grievances, addressing the medical grievances occurs at the council levels, maybe the medical council or the dental council levels, as a criminal proceedings with the police for negligence, and at the consumer forum levels. Basically, we don't have India level statistics, how much cases have been filed at each of these forums, nor it's being transparent. Nor, we do not know how much of them have been convicted or penalized in each of these forums, unless it's a super specific or media sensitive case like Kunal Saha's case, right? Unless it happens so, an ordinary citizen of India who pays tax, his case is not brought to the limelight, nor been in a part of any statistics. Statistics are mere number, but each of these numbers are life. The sole breadwinner of the family, which has emotional love bonding, etc., etc. Let us not go to that. And limiting to one study, I would say that existing CPA, the Consumer Protection Act, at a national commission level, takes about 3,000 odd days to give a judgment, bring a final judgment, not an appeal. At a state level, it is about 2,178 days. And at district levels, takes 1,320 days on an average, mean. And the compensation claimed in one specialty of medicine is about 5,75,000, whereas the awardee was about 1 lakh only. So the existing conviction rate to say the doctors are wrong is about 40% is well compared to the 30% of the Western world. So I would say that the Indian system has some, present system, the previous act has some shortcomings. No doubt about that. Patients should not be made as consumers. Patients should not be regarded as consumers. There is no doubt or second opinion about it. There are shortcomings, but per se, as Sir said, the science has some limitations. We cannot predict the outcome. Human life, the science is not still an exact science, but still an art and science. The diagnosis or the method of treatment has something. But still, the Consumer Court of India, as in present form, still considers Bolam's test, Bolito's addendum, Montgomery's test, again, check mechanism, whether the standard of care has been delivered. The problem is, as the doctor said, who interprets? Who interprets the Bolam test, the Bolitos, or the latest Montgomery test into the judicial system? The translation from medical to judicial parlance. Whether that translation has happened correctly. That is the problem. So, a medical tribunal can be an intermediary or an advisory position which has been formulated in the CPA 2018, as far as I know. My knowledge is very limited. Right? An advisory forum that provides or is in between the doctor and the judicial person, or an expert opinion, neutral position. I think that would be the first step. And no doubt the Consumer Protection Act has brought in a defensive practice, but has this defensive practice a stepping stone to address or deliver better oral health care delivery? Yes or no is a big question. Without data in hand, we could not produce evidence to the policy makers to say that yes, this has created a better healthcare or a negative healthcare model. It has increased the cost. It has decreased the cost. Without sufficient data at institutional, at district, or at the state or national level, data has to be first generated to substantiate the point of view before we even come to a common platform to discuss the turn of events, whether this is good or bad, because it's based on numbers. So we have to have concrete evidence to say this is right or wrong. In absence of evidence, nothing is going to work. So the first step to address whether this is generated is to create from existing data, this is good, this is bad. Because good and bad are just zones. Somewhere you stand in between. So we got to create that evidence, and seeing that evidence only we can say that yes, this is needed, this is not needed.
This would be, I think, in my opinion, a bipartisan or say non-committal or a straightforward view which stands as a grievance. What is a grievance and what is not a grievance based on evidence. Thank you for the opportunity.
I thank the organizers of the 4th NCML for the opportunity, especially Dr. Ravi Shankar. Today we live in a socio-cultural environment fraught with danger to the practicing physician. So we should have a system which gives protection not only to the consumers but also to the service providers. Consumer Protection Act as it stands today has many disadvantages. One, it differentiates between the patient who is paying and who is not paying, yet both can have the same medical negligence. Second, as already speakers alluded, that there is no capping on the compensation. Another disadvantage is it results in the denial of justice because medical expertise is not there. It results in denial of the justice either to the consumer or the service provider because there is no medical expertise in the consumer court. Then the next thing, it also results in the delay of justice because a judgment passed in the consumer court can be challenged in the city civil court, in the high court and the Supreme Court. Another point is, as a result of this thing, doctors resort to the practice of defensive medicine, which increases the cost of the healthcare delivery. And the lack of knowledge on medical negligence results in exploitation of the patients, leading to unnecessary litigations, increasing the litigation cost for the patient. And this worsens the already deteriorating doctor-patient relationship. And some of the patients also use this as a tool for bargaining the healthcare costs. So therefore, the way forward to the Consumer Protection Bill is either this medical tribunal or a tort reform or a social security scheme or no-fault insurance as practiced in some countries. All of us know that India is a developing country and there is no place for social security scheme where you can avoid the litigation costs. There is no place for no-fault insurance. That means it boils down to tort reforms or the medical tribunal. The disadvantage of the tort reform is that it results in unequal distribution of the healthcare delivery because if some states pass the tort reform, some doesn't pass, doctors would like to practice where there is tort reform, so the compensations are capped. And the other disadvantage of the tort reform is that it produces a product liability, so which hampers the innovation in medical treatment. Therefore, it boils down to the establishment of a medical tribunal consisting of legal minds, medical professors, administrators, where the justice will not be delayed, where the justice will not be denied because there is medical expertise, and only thing we should have, we should not have the various appeals like in the other cases so that the justice is delayed. Once you have a medical tribunal, we should enact in such a way that should not be subjected to so many layers of appeals where once again gets delayed. And also we should empower the medical tribunal to pull up the consumer who unnecessarily harasses the doctor, which is not existing in the present Consumer Protection Act. Thank you.
Before this first round ends, let us hear what Dr. Ravi Shankar has to say on this. We have taken 3 minutes.
Since the
Many aspects have come, we need further clarification.
Yeah.
Or would you want to speak after everyone finishes?
No, I want to speak in front of the...
that is after, he would be the last man to...
No, I want to give some of my presentation actually. That's the reason. No, I think everybody has told it, Shantaram sir has already told it, the delay in justice. There's only three things which I always envisage in this medical tribunal. The issue is been 90 days you get a judgment. It had never happened in the history of CPA for more than 3 decades. Judgments which had been pronounced after 20 years, 14 years. Then what is the purpose of having this act saying it is beneficial for the consumer? Definition of service, consumer, I am not bothered at all because I am ignoring it all. I am trying to give something new totally, that's the reason. Delay in justice. No case has been decided in 90 days in which it was been envisaged. It has taken years together, decades together. So the first issue of the reason is, my first issue is the delay. Then the second one is an expert opinion. I think it has happened only in the last 15 years that the courts have been asking for an expert opinion, reaching out to the medical colleges or reaching out to the district DMOs, district headquarters hospital or to the DDs in the district occasionally, not on every case. It is not been made mandatory. The main issue is the medical people trying to give the knowledge and what way justice has to be rendered to the legal people has not been pronounced properly. So they have to depend on an expert opinion, and the expert opinion has not been there uniformly in all the cases. When you have the Jacob Matthew case which says if an FIR is filed against a particular doctor or which specialty, you have to reach out to that specialty, get a second opinion and then only file an FIR. All these things, it is not there in the consumer court. Getting an expert opinion. Two are the major defects: a delay in justice and no expert opinion are the two things which has pushed the doctor to defensive practice. I will say the fear of the dagger hanging over the head. The number of CT scans taken in this country can be reduced at least by 1/10 or 1/5 if the defensive practice is not there. Reaching out to a GP, like what Ramalingam said or Dr. Arunachalam has said, reaching out to a GP, he is going to wait and do the investigation, not do it on the first day. But going to a specialist, he is an authority to give the diagnosis and the treatment. So he has to depend on the current scenario of the high-tech evaluations things. So it's not the ECG is going to be in the common, it is going to be the echo, it is going to be the intervention. It's not going to be the CT scan, it is going to be the contrast MRI which is going to be needed there for every patient. Gone are the days that the obstetricians have been practicing happily. Today, before every baby comes out of the womb, it's humpty number of elevated and fluctuated BPs for the obstetricians before they could deliver. All these things are all because of the defensive practice that the consumer has been putting it on the service provider. There are patients who demand CT scan, and if you don't do that, he is going to switch over to the doctor. Here again the reason that why you have to retain the patient. That's the reason he has to do an investigation. There are times in dengue season, you very well know the patient don't need to be in the hospital, though they might have a low platelet count. They might have a low total count. If they are in the hospital with a total count of low, they are exposed to nosocomial infection. Their vitals will be stable. They can be comfortably at home, come to the hospital and go once in 2 days or 3 days or do the evaluation. And today it is mobile which is there. They can always send the results on the mobile and get the doctor's opinion. But to be on the safer side, if the patient has come to the hospital for an OP procedure, for being in OP, and you say that its count is low and all these things, you have to admit. Otherwise, if he or she goes home, get lethargic, fall down in the bathroom while getting up from the sleep. Getting up from the sleep and falling in the bathroom is a common problem with any person who has a standing hypotension. But this is aggravated during this dengue season. But if you are quite comfortable, the cost of in a 30-bed hospital for a dengue patient to be treated for 3 days runs around 15 to 20,000. In a corporate goes to 1 lakh. So defensive practice, cost escalation in the treatment, all these things is because of the defensive practice. What I envisage in the medical tribunal is not an elected body. Elected body is always corrupt or non-corrupt. Nobody decides who has got the capacity to corrupt the voters, then they come and reach the top. Medical tribunal is what is I envisage is a sitting judge or a judge who is retired, whoever it is, they have that competence. And you have a panel of medical experts along with them to be deputed from the medical councils or from the medical colleges. You need to have a panel of neurologists, neurosurgeon, emergency physician, all specialty to have an oath taken to render and give a legal opinion along with the medical technical expert. And I envisage that there should no be adjournments on these cases. I think it has to be finished in 6 sittings or 8 sittings. Beyond that stage, I don't think most of the adjournments that happen in the court is because of somebody saying, I am not yet ready with the document, I am not aware of all these things. You are given a question on all these things. The procedure in the courts should have to be curtailed down. And that will also help the consumer courts to take up more cases in the other way and handle it much faster. None of the medical negligence cases has been closed within a year at least. Leave away the 90 days. Never had it been closed in 1 year. So if the number of medical cases gets shifted to the medical tribunal, I think it will also help the consumer forum to have a better space for their own cases. And this medical tribunal, there can be a national one and a state one, and the state one need not be there in the state alone. It can get shifted to the districts wherever, because the number of cases that is not going to be too high. While Sir was talking about statistics, probably the Department of Statistics, Government of India has not produced it, but there is a list of judgments that has been pronounced. It is the duty of something like IML, IMA or your association to go into it, find out the cases and do it. Probably we'll have a difficulty in getting the statistics, but don't ask always the government to do it. Let us also be part of it, trying to do it and give it so perfectly that it's been accepted by the government. And this volume of cases definitely is going to come down, and this state level medical tribunal can go along the districts, can finish the cases in the districts, and an expert can be there from all the medical colleges are there in just 150 kilometers or 200 kilometers. And then people on that specialty be present there, all the documents given. I think somebody with the medical knowledge giving it properly can definitely finish off these cases in hardly 6 months time. A dagger hanging on the head of a doctor definitely is going to be a defensive practice. I always quote the case that happened from Chennai, which went up to the National Forum for 22 years, where a child was operated for an inguinal hernia, became an adult, bore a child. At that time, the judgment was delivered, sustained. The judgment was for 1 lakh. In 20 years, what is the value of 1 lakh? That is why that was the case which had stimulated me a lot to do on this medical tribunal, sir. Thank you.
Sessions will continue. If I have to attend the other 2 sessions also. Yeah.
If I am allowed to speak only 1 line, I can't say more than that. I fully agree with what Dr. Jayashankar has said. Each and every word. Although Mr. Vajpayee, you are noting down, they are my personal views.
Okay. No, not yours.
I fully agree with what you are saying. But very useful points have come up. Very, very useful points. So I think this forum, Dr. Jayashankar, I must compliment you. Very, very useful points have come up. One is what comes to my mind is sitting here. Law on medical negligence. I don't think we have any law. Consumer Protection Act only says deficiency in service. Most on the part of a builder or an insurance company or this thing. But if it is possible to have some law on medical negligence, I don't know whether it is there in other parts of the world, but there can be some law.
It is there in the GMC in the...
So some law on medical negligence.
What is the full form of GMC?
General Medical Council that governs the UK.
So a similar thing we have here is MCI.
Yes, we have MCI.
Yes, so MCI has regulations.
But what is medical negligence? What is the accepted term? Then very important part is, so many people have told me, capping of the compensation. You see, in accident claim cases, so there are some well-defined kind of things. they say that this is the cap on the compensation. There I don't think there is anything. There is a cap on compensation. So if some kind of deliberation could be started on this, can we have a law dealing with all aspects of medical negligence? I think that will be a very useful contribution. That is number one. Now, so far as the time schedule in deciding the cases is concerned, nobody can disagree with that. So given the system, things are different from place to place. In my hometown of Chandigarh, my judge claims he doesn't take more than 90 days in any case, whether it's a builder case or medical negligence or all that. So there are states where they take more than 10 years. So it depends on various factors, infrastructure, so many things are there. But I can't, say more, to agree with this thing, that there has to be a time-bound disposal. Now coming to the medical tribunals, so I must mention certain points I want to bring to your notice. One is, of course, Dr. Jayashankar has clarified. So we have a system of tribunals, say income tax tribunal, we have defense tribunal, we have for so many other things, accident claim tribunal. So given the system, Mr. Vajpayee, you may understand it better. I think the system of our constitution, then what do you call it, division of powers between executive and judiciary.
Separation of powers.
Separation of powers or division of powers. So what Dr. Jayashankar says is correct. That this kind of tribunal, it has to be headed by a person, a judicial person. But by whatever definition he is called, it has to be a judicial person. Otherwise, the Supreme Court or judiciary will never accept it. That is number one. And that judicial person, so there could be prominent, specialists from the profession. As he says, there can be a panel, of course, there can be a panel. So persons can be appointed in income tax tribunal. There is a judicial person and an income tax person. So like that, here also, if the doctors are sitting there, I think that will be very good. There can't be anything, to say this is not a good suggestion. I think this is the perfect suggestion. That there could be a panel. This is there in England as well. Even for civil judges, it is there. If a judge goes on leave, there is a panel of advocates. So one person sits on the bench. So here also a kind of panel could be there. But here the catch is, this is my personal opinion. If you have a system of medical tribunals, it may give rise to an increase in the number of cases to be filed, because it will be an incentive for the persons concerned. There may be more and more litigation. There could be there. Of course, it is a matter of opinion, but there could be there. And second thing, the writ jurisdiction. High courts, Supreme Courts. The writ jurisdiction, as mentioned in our constitution, it has to remain. So against the decision of medical tribunal, the litigation in the civil courts, that means High Court, Supreme Court, that can't be ruled out. So if you say that medical tribunal is to be elected by somebody, I think that may not be permissible under our constitution. So it has to be a judicial person, aided and assisted by professional. That could be the constitution. And one more point of violence against doctors. Let me tell you, I was working in the state of Punjab. Basically I am an IAS officer, I am not a judge. I was one Home Secretary there in the year 2008. We took the initiative with the help of the IMA. So we drafted a legislation and got it passed from the Assembly. And in 2008, the law was enacted in Punjab. I have the text of that with me. And the people of the medical fraternity tell me that after that, for a number of years, that served as a deterrent. So the incidence of violence against doctors, so there was a sharp decline in that. So now even after the incident in Calcutta and all that, I think there is some thinking that there could be a national level legislation on this. But it is a need of the hour, I agree with that. So I think these were the points And so far as the working of the consumer fora and all is concerned, so that we reserve for the afternoon, whether it is Bolam or Bolitho or Montgomery, nothing to do with India. This is all with UK. All these cases are from UK. And so far as India is concerned, Bolam was the first step. It is a strong mandate from the Supreme Court, follow Bolam. And we are following it, not even Bolitho. In one case, I felt like going ahead and follow Bolitho. But Bolam is as directed by the Supreme Court. If somebody doesn't follow it, somebody from the consumer court anywhere, he is liable for disciplinary action. This is what I want to say. So this is the law of the land. So these were something I wanted to say. The rest we will do in the afternoon.
I would like to respond to the two questions you raised. One is the increasing litigations in the case of the tribunal. We should have a mechanism where people go to the tribunal and lose the case, the customer should have a penalty. So unnecessary litigations can be avoided if you have a penalty in the medical tribunal for the people who unnecessarily harass the doctors.
Even under the but we don't take it forward.
But we should take that forward. That is one thing, so that unnecessary litigation is avoided. And second thing, can we have, above the tribunal, one appellate authority decides if you are going to go to the civil court, High Court and Supreme Court, once again it is going to be delayed like what is happening now.
Yeah. Okay, sir. Okay. Yeah.
Sorry.
Can you throw some more light on that UK regulatory body, how it works, what it works?
Hi. The General Medical Council is very similar to the MCI, which strictly governs the practices and the professional activity of the doctors per se, both from the licensing perspective. So it governs the licensing perspective, it governs the qualification perspective, it governs the experience perspective, and also the attitudes and the behavior of the doctors. To the extent, even if you have a professional misbehavior, like a misbehavior with a patient or a patient attender, even that comes under the General Medical Council, which will be referred to something like a tribunal, wherein a group of people sit and see whether what that particular person did is appropriate or not, and then it gives the final verdict is whether you continue your license to practice or your license to practice is suspended. This is the basic the work pattern of the General Medical Council. With regard to the not the consumer code, with regard to the compensatory payoff and things, the GMC doesn't actually give any orders on that. It gives a recommendation that saying that this particular person, after being considered with an expert panel who have discussion. In the discussion, if you see, there will be a sitting judge, there will be a patient or the patient's attender in case of the victim passed away, the concerned doctor and the expert panel. All of them will sit together, have a decision, look through the documentation and everything, see what and all the communication has been given, and then finally they will come with a recommendation to the court saying that so and so things have been done on order and so things could have been done much better or has been avoided due to either it is a lack of knowledge or either it is a lack of awareness or gross negligence. So again, the compensation will depend on the recommendation. If it is lack of knowledge, that particular person is allowed to go retraining rather than straight away penalizing them. The GMC recommends that that particular person should undergo retraining before he further practices on the particular specialty and things like that. So this body will meet with the panel, gives recommendation, and then this recommendation is implemented by the courts for compensation.
Mr. Vajpayee, It's entirely a different environment. In UK, most of the medical work is carried out in a regulated environment by the NHS. Only less than 10% is outside NHS. Here 80% of the work is outside, any regulated work, it's only in the, what would say, it's independent clinics, private clinics, where all these years there have not been any standards. And another thing, the work environment there is, everything is reported because it's all in, public sector institutions. And accreditations and trainings, in-service trainings are mandatory. Every year, one has to get continuation from the GMC.
No, this once in 5 years, revalidation. 5 years. Once in 5 years.
Okay, once in 5 years. And the credit hours, CME credit, all those things are coming here now. See, best example is about 25 years back, Shantaram would agree with me. 25 years back, for diarrheal diseases, pectin and kaolin was the treatment. If somebody says pectin and kaolin today for diarrhea, he will be failed in the exams. No binding agents, isn't it? Like this, lot of things have changed in medicine. And it is never, see, I would rather sum it up like this. You can talk about standard of care, but it's not standardized treatment for all the diseases, at least for all the 80% of the diseases you may standardize the treatment. At least for the 20%, it's left to the wisdom or the experience of the person whoever dispenses the treatment. So that is a very great grey area where the medical personnel alone can understand. And if you are not read for 5 years the current developments, you may not be competent to say that, isn't it? But that is the major issue there in UK. It's continuously doctors are trained and their credentials are updated, very validated. And even this, skill development. Even this medical practitioners tribunal services, it was debated much longer time in UK also. They wanted to separate the regulators from the adjudicators. The regulatory powers and registration powers, they wanted that to be separated from the adjudicatory power. So this adjudication alone is taken to this medical practitioners tribunal services. The regulation is still with the General Medical Council. And this tribunal functions, the General Medical Council is the umbrella organization still. The tribunal is one of the arms of the General Medical Council.
Yeah, it is a separate body actually.
No, it's one of the arms of the General Medical Council. It
doesn't come under them directly.
Not directly, it's the umbrella organization is the General Medical Council. It's not the regular courts. It's not.
But just now what he shared was that this body acts as an intermediary before the matter goes to the court.
No, it's not intermediary. You can have an appellate, but they can pronounce the judgment.
It is a referral body which gives its
So
opinion,
it is
recommendation.
a sort of a permanent structure.
Recommendation.
No, it can.
I'll just want to be clear. In India, what happens? The matter goes to the consumer court. Okay. After that, the consumer court may take a decision. My voice is good, friend. That's my business. Consumer court, the judges may decide that this matter has to be referred to a panel. They will refer it to some government hospital or to AIMS or PGI. What I understand from what you say is that something like this.
No, it is not an expert committee. It's not an advisory body. It's an adjudicating body. They can award punishment. They can award punishment. It's not an advisory body. It's an adjudicating body.
So can the medical tribunal be suggested on the lines of something like that?
Yeah, naturally we have been following them. All the while we have been following them. We'll follow only them in this also, but with tinkering here and there. Whatever the problems they have had all these years, we should try to weed them off, and we should have.
They don't give any monetary compensation. They give regularization recommendations.
Otherwise, Nandakushar's, I'll compliment him like this. They are taking care of or they are punishing the errant doctor, but they are not compensating the public.
Yes.
Probably with this punishment order, the public can go to the another court and get their
So
compensation.
that's what it is. The error of deficiency is decided by these experts.
By this
Yes.
Yeah.
While they are the
So
courts will
in the
decide on
American
the
system, there is a small twist.
jury.
There is a jury trial. So what happens is the jury listens to whatever has happened. Amount of compensation, guilty, not guilty, no, it's little bit different.
No, in fact,
Even guilty, not guilty, there is decided.
Bajpayee, definitely we should never ever remind anyone that there is a jury system, because that's one of the worst systems.
Yeah. We have 3 more participants. Sir, we have 3 more participants who have joined late.
Latecomers.
No, sir.
Bhupati and
Sir,
Muthrajana.
So, anyway, sir, we need 3. We just have completed our first round. In the first round, we all took 3 minutes to express our views on 2 things. Number 1, has the Consumer Protection Act delivered the results that it ought to have delivered in healthcare, or has it failed? That is the first question. If we come to a conclusion that yes, it has failed or it has not delivered proper result, or something better could be done, what could be the better alternative? Whether a medical tribunal, yes or no. Before doing that, sir, only 1 minute, you will introduce yourself on the camera. Wait for 30 seconds before speaking on this topic, each one of you. Then we'll have the second round. Just look at the camera and speak.
Good morning, all. I'm Dr. Gauthaman, Medical Director from Raila Institute and Medical Center, previously Medical Director in a global hospital. And
now your views.
So, my views.
You have 3 minutes.
Yeah, okay. I don't have that much to talk, but then, so Consumer Protection Act, actually, when we speak about Consumer Protection Act, I somehow feel like, the terminology itself is little vague, because it's consumer, okay. The consumer, when we define a consumer is one who consumes either service or product, but then when it comes to the value that we add to the life of a patient, the treatment point of view, we don't discuss from the business point of view. Of course, the corporate hospitals don't discuss from business point of view about all the cases that we are dealing. But in a real sense, between a doctor and a patient, it doesn't transpire as a business. So, Consumer Protection Act is something which is like little, we need to redefine this term itself actually. And I think, we feel like whatever that is being done is good so far, but then we can fine tune it and make it more inclusive on certain things. When doctors feel like we are not given the due credit, and when we appear for when we are taken up for the task, in the medical legal negligence and all that. So we need some more inclusive arrangements. I think we can discuss about it, but then that's my point. Being more inclusive about redefining the act itself. Yeah. Thank you.
I am Dr. Bhupati John, consultant surgeon and practicing at Chennai Ashok Nagar. My view is actually the Consumer Protection Act, every consumer has got a right to know, to implement their thoughts and their thoughts and the rights. The problem is in India, one section is the consumer. The another section is the implementing agency. That is called maybe a judiciary, maybe a government agency, everything is. The problem is the facilities to be given to the institution and to the administrating agency properly without any inequality. Because if a consumer going to raise a question, for example, one instance I will tell you, a government institution or to pave the road properly. Suppose if there is any dent in the road, the problem in the road, they will fell into accident, they will cause a damage, they lost their life. Again the people, this is one example. Again, the people going for the court, they going for the claim. This is what happened even in the US also, because of there was a problem in the road, they got a claim. They sue the government for their compensation. Here the facilities, the law should be made, the procedures should be made, the rules and regulations should be made according to the availability, according to the present prevailing condition. Here the problem in India is, they are making a rule without having any availability, without having any source. They want to make a good roads, but they don't have facilities of gravel or maybe sand and everything, but they want to make a good roads. What is it? The rule should be for the people, not people for the laws. That is what I want to mention. So create facilities and everything in a proper and pakka way. So that is what I wanted to stress it. Inequality to be rectified. This is what. So consumer has got every right to know about everything about the judiciary, in the government, in everything, because it is a transparent world. There is no hidden agenda except in what we call the military or maybe a protection areas. Everything is to be transparent. Everybody knows what is being done. Thank you, sir.
Dr. Muthurajan, former Deputy Director of Medical Education, Government of Tamil Nadu, and past State Secretary of the IMA. Sir, regarding the Consumer and Consumer Act, every consumer will happy once the patient get discharged with happy. Suppose in spite of several attempts to buy the doctors, the consumer again turned against the doctor. For the past 4 or 5 years, more and more cases consumer is higher up. Because of the people thought they gained the money through the consumer. They want some compensation through the Consumer Act. That is, attitude is not good for the profession, good for the community also. At the same time, another thing we must think it of, the relationship with the doctor and patient is now very broad, not nearby. That is this angle we must think it of. Once the patient-doctor relationship is good, definitely the case of the concern will also reduce. And this is my important point I want to discuss to the community.
Few friends said, and then we all will come to a conclusion what are the important aspects on which further deliberations are required, right? Do we all agree to that?
Yes. I have one doubt.
Yeah.
You know, we've discussed about Consumer Protection Act, and on behalf of doctors we spoke so many things.
Yeah.
Are we going to look at the patient's perspective?
Absolutely,
as well?
we should be. We should be.
Probably for a minute, I think we should forget we are doctors and see what is happening to the patient side. Why is it important that they are actually filing a case? What is happening? For example, one of the key things is, though we say we have to form a medical tribunal and things to protect when they form a case, what are we supposed to do to avoid them filing a case? And what is that we need to improve? One of the definite factors is, let's all be frank, if I don't know a doctor today and I go to a hospital or anywhere, I'm afraid. Personally, I'm afraid. All of us are afraid. Let's be frank. So what has led to that? So how can we improve that basic rightness in us and bring back the confidence of the patients back to our side? Because I understand this is going to be portrayed and projected to others to see that policies are made. But if we speak only from one side and then ask them to make a policy, it's a complete biased policy. It should be on both sides. So from the patient's perspective also, there are some deficiencies which we have to accept and try to correct them.
So we'll have that one question, everyone will answer.
Both of them, but this
Yes.
is what he says, from an empirical medicine, we are moving towards evidence-based medicine. Earlier it was the gut feeling or intuitive thinking or instinct of the doctor. Most of the time this started one particular treatment. we are, from empirical treatment, we are moving towards evidence-based medicine. Earlier, it was the experience of the doctor, or its gut feeling, or based on his experiences, its gut feeling or intuitive thinking that decided most of the treatment. Now, patients ask for evidences, your colleagues are asked for evidences, law is asking for evidence. That is why most of the times the excessive investigations and the other things are happening. And as many of us we have voiced, it's a defensive medicine that we are practicing. And probably Nanda Kishore's apprehension is there are treatments which may fail to meet the standards being dispensed in the arena. But again, this is an abstract science. It's not an absolute science. That is the problem with the.
One more aspect that someone had really raised, that are we doing enough to have proper standards in our country? Yes. Okay. That onus lies on the medical fraternity.
See, I don't.
Among the crowd in the forum, how many of you are ready to show your body for interest to the current generation of practitioners? Because the mentality of teachers as well as teachers have totally changed from the past to the current scenario. Both the mentality of teachers as well as students has changed drastically. Because nowadays the students have a mentality from the plus 2 standard 2, they have to reach to the level of MBBS. While doing the MBBS career, the aim is to prepare for the specialty, PGs. Again the same, when they are doing the post-graduation, the mentality is to attain the specialty, not to focus on the current area of practice. So, we practically saying, I see a case that last week actually, referred by one doctor, I don't want to mention the name and the area of where he gets the degrees. For a common illness, commonly tinea corpus, everyone knows, practitioners, they have been prescribing IV prednisolone, IV for the past 1 week. So, doctor is qualified as issuing a wrong drug for a patient, falling in the degree of MD. I don't want to
wrong diagnosis is not negligence. See, okay, but
that is fine. So let us come down to the core issue that we are trying to discuss today.
Yes, sir. Yeah.
Standardization of practice by medical council or by IMA or by
Absolutely.
government.
That is the need of the hour.
And I think there is a preferred mechanism already, preferred practice pattern issued by the professional bodies, right? So that could be the baseline. So you cannot standardize treatment because each patient is different, their affordability is different, their genetic makeup is different. So you can't really standardize care, right? What you can prescribe is preferred practice. Within this level of practice, that can be considered as a not negligent. And beyond this, if you deviate too much, but if you go for standardized treatment, two things will happen. One, innovations will be cut down. It cannot be customized. Right, each patient needs customized care. So that is the doctor's responsibility. That is within our ethical concerns. So you can't have prescribe each and everything word by word. It's very, very difficult. Even though we issue, say, I'm part of the technical committee of NABH which prescribe the standards. So when we describe and write the standard, it will be really generic. It can't be descriptive to each and every specialty. It cannot be descriptive to each and every location because there are so many variations in this. So the standard of care, rather than standardized care, it should be preferred practice patterns for each specialty given by the panel of experts from that associations, governing councils or associations.
That's the most important. Which
yes, and I think the court doesn't take this into consideration. The court has to take this into consideration because that is prepared by experts. In American jury system also, the ASCRS or the American Academy of Medicine prescribe every year it releases preferred practice pattern. Every year it is updated and court considers this as a document. Reference document.
That's why this whole issue is being taken by IML.
Yeah.
IML wants to make a standard protocol, systems, advices to the judiciary. That's why you are all.
I'll share something with you. The problem that the judiciary faces, what advocates face. I'll give you a very simple illustration. Law in India says that for every invasive procedure, you need to take a written consent. This is the law, standard set by law. And this comes from IMC 2002 regulations. Now, which are the procedures for which consent must be taken is a big bone of contention.
No clarity.
No clarity, especially, I'll give you an example, removal of CSF fluid from your spine. 5 state consumer commissions in India have held that to remove CSF, you don't need a consent, it is not an invasive procedure. There are 2 state consumer commissions which have held that no, it is an invasive procedure, it is a non-routine procedure, you have to take consent. Now, who is going to guide the code? Please understand, I understand you are doctors, but as a lawyer it's my duty, obviously as moderator it is my duty. Law has nothing to do with medicine, and law should actually do nothing with medicine. Whether paracetamol is the right drug for fever, no legal person can comment on that. Court will never comment. Court is going to ask another doctor. It always takes opinion wherever issues related to medicines come before the court. Either the contesting parties, they bring affidavits of other doctors, or the court refers the matter to medical experts. You give us your comment whether paracetamol is right for fever or not, and you please bring medical literature whether Harrison says or it does not say something like this. Okay, now here lies the problem. Whether removing CSF fluid is an invasive procedure, non-invasive procedure, whether consent should be taken, not taken, some very basic aspects. The societies can come out with the standard, you call it whatever you call it, you may call it preferred practice patterns or whatever it is, but you should be coming out. One very simple example. Nephrologist, day in, day out, they have to be there with the dialysis patient. Nephrologist Association till date has not come out with a clarification whether a consent which is taken once for a dialysis, because the dialysis patient is going to be on dialysis for years. Now, corporate hospitals have come to me asking my opinion in writing, sir, for dialysis, whether we should take one consent, it will be applicable till the time the patient is there with us, or for every time he comes we have to take consent. I say, who am I to decide? Either the court decides in a matter that no, you have to take consent in every case, then I will give my written opinion, or let the society decide. So even on these very small aspects where clarity is required, unfortunately professional bodies are not working in this direction. You see these, recently I had an opportunity to see, you call it SOP or whatever you call it, on fever by American AMA. 3,000 pages. A talk only on how to deal with fever. The amount of, someone told me this is required for their court cases, fair enough, whatever is there. They have put in that much efforts. Unfortunately, we don't put it.
Standard treatment guidelines are issued by
the government of India.
Every state. In India, it's a state subject. So in Tamil Nadu, we have, it's been revised recently also, 2018, for every specialty.
9 years. After nearly 9 years.
9.
Standard
No, at
treatment
least it's
protocol
been
cannot
in
be
place.
taken to the court because I think it will differ, like what he said. It varies from patient. In India, with such a vast economical difference, it cannot be standardized. It can only be a guideline. That guideline alone has to be taken by the courts. I think IML should have to push forward for guidelines. Standard treatment protocol is totally different. Government can give it, that can be implemented in the government hospital, and I am very sure 50% of the time the government hospital itself will not be able to implement it.
No resources.
Resource. Both human as well as financial resource will not be there. Asokan sir will be very strong on that point. That is difficult. In India, everything has to be customized. The whole system, the medical fraternity failing is, we don't have an Indianized treatment protocols. We don't have these associations bringing bringing out standard treatment protocols, guidelines, or whatever it is.
What we do on field.
Practicality, I think IML with this, all these things should have to write to all the association to try to get some, not on standard treatment protocols, but guidelines, so that it can be taken by the courts. If it is going to be a myocardial infarction, whether they have taken an ECG, given the first line of drug, what it is, refer to the tertiary care center, whatever. It's very simple. It's very, very simple. The only thing, you don't need to go try to find out what is economics and then all these things. What is the basic minimum that has to be provided? That has to be there. Advance when they go to the tertiary care center.
So I'll just sum up the, okay, sorry.
The other reason why litigation is
Can
going
you
up.
all look at the video?
The other reason why litigation is going up is because the trust and communication is falling down. There is a trust on the doctor.
Trust and communication.
When you see in the villages, you don't have that much litigation. But when you come to a city, litigation is going up because the trust on the doctor and the communication, main thing, communicating all about the diseases, and informed consent is not given properly by the doctors because they're not having enough time probably, or the other factors. So that is the deterrent factor. And the other thing is the media. The media is highlighting certain cases which is increasing the litigation. That's the unfortunate thing.
Another thing, what is pushing the litigations increase in the urban areas is moving from the family physician concept to the specialist concept. I think we should, on the lines of the UK model, I think regulatory authorities should implement that model so that the doctor-patient relationship improves and the confidence of the specialist is high when the GP refers them to a specialist.
So we have two corporate peoples here, Balaji Pillai and Gaudaman there. But I always, another person. But I was started telling in a different tone nowadays. The corporates should only have satellite clinics. The corporate, in their place where they give tertiary care, they are not supposed, they should not go in for a day-to-day outpatient procedures. This is away from this context. The family physician concept. If the family physician concept is also introduced back in the country, I think the number of litigations going to the court or the mistrust between the doctor-patient relationship will come down a vast level.
If we could just keep our conversation
to
Consumer Protection Act and the medical tribunal or any other alternative. Yeah, please, sir.
So yes, continuing on what Dr. Ravi Shankar said is, yes, I mean, as we have been practicing the British medicine for many years to start with, and now that we are also now imbibing some more practice from the other Western world also. But one thing that is needed currently is, first thing is education of the patients, second thing is the right communication. So these are the two things that will bring in the trust, which is moved the patient away from the practicing doctors. In the rushing hour, doctors forget to say that, okay, I don't have time. It's better they spend 2 minutes or 5 minutes now rather than spending 2 years explaining that particular case. So this is where it is very much important for any institute, whether it is an individual practicing or healthcare provider or whether it's an institutional healthcare provider. So this is the basic fundamental that any institute should adopt to. Second thing is, when Ravi Shankar said, you were touching upon the point of the tier system. The patient who's coming through a referral, proper referrals, I'm talking about a family physician referring to the specialist, and the specialist, he finds that it has to be referred to the super specialty or the subspecialty. The patient has got complete 100% confidence on the system. But now with lot of advertisements and media coming into playing, yellow journalism and other things, is giving a big misguiding the entire society in the wrong passage. This is where the patient today is confused. Even for a small fever, they end up paying 5 lakh rupees in a hospital, which could have been cleared within 5,000 rupees in a small nursing home. Likewise, a patient could have been saved if he was referred to the specialty or the institute at the right time by the family physician, if the patient had approached the family physician at the right time. If the patient is going directly to the institute or the corporate hospital, that is where again, like you're talking about a defensive practice, or you talk about defensive practices come because of the evidence-based practice. Because they have to say that we go by the standard SOPs, we go by our institutional way of putting up the systems. This is how our what you call protocol says to practice. At the receiving the patient, the ER is supposed to follow this many protocols of investigation, this many protocols of referring to the particular specialties. Wherein if it was a referral given by a particular family physician saying that this is my query diagnosis, this is where I need your support to clinch on the final diagnosis and treat the patient accordingly.
Add on to you, sir. From the beginning, what I told and Professor Santharam added, even institutions can have family physicians from the door to door. You should have a senior consultants who worked with you as a DMO for years, appoint for particular patient. In my duty, I am a senior, residential medical officer who receives your patient at the door. Whether it is a cardiac patient or neuro patient or it is an accident patient, I should be responsible until he exits from the hospital so that I can communicate better to the patient and to the consultants and give the feedback to the medical fraternity of your institution, and your institution confidence will improve if you have family physician as your backbone of the system, not your consultants or anyone else on the floor to floor.
Yes. So we'll come down to the Consumer Protection Act and Medical Tribunal. One aspect that we all were concerned about is that doctors obviously cannot be branded as service provider and patients as consumer. See, in all other types of products and services, the outcome can be guaranteed. But human body, ultimately law also accepts that human body has yet not been 100% deciphered. Many mysteries are there. Okay. So then how do you, obviously, Consumer Protection Act may not be able to give complete justice. One or rather two big shortcomings that have come out of this Consumer Protection Act. One, rise in defensive medicine. Obviously a country like India cannot afford defensive medicine, but nevertheless it is the truth of the day, let us accept it. And yes, trust deficit. It is increasing exponentially with every passing day. We should be devising standards, protocols, or as it was said, no.
One thing you have to clarify as a legal expert.
Yeah.
Why should you differentiate between a patient who pays and who does not pay when
I'll
they same negligence?
Okay, I'll do that. I'll give that clarification. I'll just sum it up. I'll give you in medical tribunals, there should be experts, medical experts. One suggestion was we should also have persons of public stature from non-medical backgrounds also, along with a judicial person. So it should be something that appeals to everyone. But again, our experience of such persons of public stature has not been very good in India.
No, but then that will come to like similar to a consumer court. How is it going to be? Even there you have a judge and a social worker and a lawyer in the panel.
No, so generally, so here what we mean by medical tribunal is that it will look exclusively into cases of medical negligence only. Medical malpractice, to be very broad.
Sir, is the proposed CPA's medical mediation will be more or less similar in composition to what you say?
See, mediation can be done anywhere. Even today, if you see, law per se, It is promoting whether amendments have been brought to the civil procedure codes everywhere. So the government is obviously trying to, at a policy level, trying to.
When entering a CPA, there are only two things: whether the doctor has given a not standard procedure, is there any negligence established? If so, what is the quantum to be compensated? There are two. That is the bottom boiled down points. If there is a mediation council composed equally of doctors, social and laypersons, what would be the terms of the mediation?
No, so mediation per se means the parties are ready to walk out. But when you say tribunal, there is a compulsion to go there. That would be a big difference between both. Mediation and conciliation is fine. See, mediation can go.
Like the power of NGT, you know the power can really shut down institutions.
Yeah. So when we talk about a tribunal, then it would obviously come into existence by a law.
Binding on both parties.
Absolutely, it will come into existence and every matter has to be referred to that. For example, we have debt recovery tribunals.
The quasi-judicial.
We have National Green Tribunals.
The quasi-judiciary body.
Quasi-judicially, but compulsorily all matters have to go there.
Mediation starts when the guilty is accepted.
No. It is not. Mediation is.
Mediation can happen concurrently also.
Yeah, it is a no fault compensation.
So it is like this. At times judges say.
Now CPA 2019 is
Mediation.
So mediation means both the parties have to agree. In mediation, there is means the mediator need not have any qualifications. He just has to be acceptable to both the parties. In fact, the world's best mediator is only 9th pass. World's best one.
And you don't talk of the past. You don't talk about the incident what has happened. You just talk about the future. What has the
So let us.
Otherwise, mediation, arbitration, adjudication are different.
Absolutely. All have different. Arbitrator has to give an award after all. Mediator simply has to go to the court and say we have failed. Let us go. It is going on in the Ayodhya case. So even though the hearings were going on, the mediators sideline by side they were trying to bring the parties to some understanding. So obviously that would not work because even if mediation comes, Consumer Protection Act and consumer courts and consumer cases will.
So because there is a provision for mediation 2019.
That 2019
It can't be compulsorily done. It will be okay, fine. So that
There is a
will
provision.
become a.
It's just a suggestion. That's all.
In fact, out of court settlement has got another name for mediation.
Yeah, it is a similar to that. It is
It's after informing the court, you are doing.
Panchayat, sir. Panchayat. Tamil sonna panchayat.
Absolutely. See, this is the beauty of what the Britishers have done. Our own panchayati system which was there in the villages, they have taken away. And after 100 or 150 years, again now we all are coming to the conclusion that that was the best system to deliver justice.
Now also the village sides, Panchayat only is solving the problem against the doctors.
Acha. Solving or making more problems?
No, there is a difference between Katta Panchayat and Panchayat. Like your what's that?
Kangaroo courts.
Kangaroo courts. Okay. So obviously there is a question mark on the capabilities of the judges of Consumer Protection Act in consumer courts to deliver judgments on a subject like medicine, which is far too technical. So obviously doctors have fear and they don't take complicated cases. This again is one shortcoming. Adverse consequences, cost of healthcare is going up. Okay. And we are a third world country, yes, let us accept that. How should the panel be? One suggestion was it should be balanced and it has to be stringently implemented. Doctor's viewpoint must be taken into account. Obviously, by medical tribunal we mean that compulsorily it will comprise of one doctor in the panel. One of them could be a non-doctor also. Clinical Establishment Act, what impact would it have on Consumer Protection Act? Now, unfortunately, we have brought a Clinical Establishment Act. A Clinical Establishment Commission will be formed under the, that is what the National Clinical Establishment Act says. But all other forums will keep on troubling the healthcare providers. So that becomes an additional forum where doctors can be sued.
Sir, half of the work will be done. Basically, Clinical Establishment Act, if properly implemented in word and spirit, all the documentation procedures which are actually formulated and established inside the things, the registers, everything, will form the basic level documents which can be used or extrapolated to the consumer forum or anything. It's basically duplication of work. Same documents can be submitted here, Xerox and submitted here. So basically,
It's not duplication or anything. Medical profession and hospital has never been regulated. Anybody can keep a petty shop. The same system was followed in this country. Now regulation has come, they have said you can't have a petty shop, you have to have a square feet area of place to practice your profession, basic equipments will have to be there, all these things are there. This is only a Clinical Establishment Act. If you don't have that provision, you can't practice. And when that is there, Clinical Establishment Act is also semi-NABH. There are a lot of documentation.
Most of the standards came from NABH standards because I was part of the drafting committee at the Delhi Establishment Act. 30% of standards was taken from the NABH main standards. Whatever that could be implemented at 80% of the hospital was taken from the NABH standards. So that is what then paved the way for the present entry level accreditation, which all the insurance and health ministry is really focusing on as the basic standard of care. Second thing is about the Clinical Establishment Act. It's never been implemented. I visited hospitals across all the states of India. It's never been implemented in its full spirit and law. It's just another licensing. It's becoming another licensing mechanism to feed the corruption into the system. One thing what Clinical Establishment did to Indian hospital is, the hospitals were brought under the government by one single stroke of law. Other than that, it didn't did anything. No, last 7 years. It's been 7 years since the first union territories implemented, and all the states, all the ruling party states adopted it first, and no major change within the hospital except that one more license to the hospital with big cost. And biggest beneficiary is the government system. Joint medical directors.
And Dr. Nirmal, I want to ask you one thing. I'm sorry, I'll take just 2 minutes away from this. Recently, I read in the papers for a dengue death of a school student, the school has been fined 1 lakh by the government. Is it legally correct?
No, sir.
How is that? The government has levied 1 lakh fine on the school.
No, after the strike by the TNGDA, it was withdrawn. So they neither have the authority, because it was too polar system. The treatment was given by a doctor working in ESI in a private hospital. So for some perceived negligence, they have just gone and cancelled the license of the hospital. So the JD has really gone above the law. Okay, this is authoritative.
Fine on the school also.
Yeah. So they have withdrawn.
Any public places that harbors or has the...
That was a different act. It's a Public Security Act,
Public
Social
Security
Health Act.
Installed by the corporation or the respective local governing body. They have the right to inspect your place, and if your place has led to a situation that mosquitoes breed, you are liable to be...
No, the law says that if public health is endangered.
What generally is done?
Generally is done.
We had a IS officer right now here.
Yes. Sir.
So we can ask him informally. What actually happens is, whenever such things catch media attention, they will come out with such a order, which the other person can go to the High Court and get it quashed in half an hour. As good as that. So that quashing will happen after 4 months.
Yeah.
By that time, everything.
After a few hospital admissions from the doctor's side
Clarification, sir.
and few heart attacks.
Important thing, sir. As per our Medical Council of India guidelines, the case report or case sheets or case notes, whatever names it costs, if asked by patient in writing, upon required minimum payment, it should be produced within 72 hours to the patient. Listen.
Not produced, provided.
Provided.
Copies, not
Copies.
the original.
Copies.
Only of IPD patients, no OPD patients.
Yeah.
You are not bound to keep records of OPD,
OPD
patients.
patients.
As good as that.
Yes, sir. If it is not provided, so what is the legal implication?
So then that patient will go to a consumer court, file a case, wait for 8 months, 9 months, 2 years, 10 years, get those copies. And in fact, patients have done that and doctors have paid badly. Then they file a second case after getting medical records. Now I have got the medical records, now this was your negligence. And the court at these times are biased against that doctor or hospital. They just don't listen to logic. This is on? Arey yaar, my practice will stop.
This has to be corrected in the tribunal, whatever the next phase of improvement, this had to, because if the thing is not provided, there should be a stiff penalty which can be brought under the Clinical Establishment Act.
So you
So,
mean
OP register should
OP register should be maintained?
Outpatient.
Outpatient.
You are not required to even write it down. Not even for an hour you are required to keep it.
But in the act
Says 1 year. Clinical establishment is applicable here?
Yes.
Yes. So then that's
In
a-
Tamil Nadu, it's applicable.
So then we'll have to look. So under clinical establishment you have to keep it. But under the IMC regulations which are applicable across India, okay, now Clinical Establishment Act will take over all those parts which were not covered by Indian Medical Council regulations.
But there is a parallel notification from the DGHS, Director General of Health Services, OP record for 1 year, IP records for 3 years.
Medical legal indefinite.
Indefinite, and pediatric indefinite. So most of them following that.
No, but whether the notification of DGHS would be applicable to a private practitioner?
Yes, because the court has taken this as a reference document.
That they may take, but it's not
Because nowadays, many of the specialities,
applicable to one
the,
of the institution under the DGHS.
no, that is a law for them. That is part and parcel of the law of the mandate of DGHS. The private practitioner, the hospitals, the note, they say 1 year, 3 years and 6 years. Now it is part of the Clinical Establishment Act.
Yeah, clinical establishment is a different ballgame. So anyway, we'll just go through this and we'll come to our core. One passing reference was done by Sir, which was very important. And on that I'll just put light after I complete on tort reforms, no fault compensation scheme. Because these are the alternatives which are working, which have been put into work in other countries. Okay. One suggestion was that when it is referred to experts, even by the Consumer Protection Act, it must be referred to the experts of the same specialty. That is generally done. So if the expert panel is not from the same specialty, the court does not consider that expert opinion to be a good expert opinion. Okay. Elected body for a tribunal, again it is the duplication of State Medical Council and MCI. It won't work. It's the same thing, what else? Okay. No adjournment on that, no one has a control. Adjournments will keep on happening in courts. Okay. So very broadly we have come that yes, clinical establishment could be one alternative forum. Mediators could be another alternative forum. Another suggestion which has come was that in between there could be a compulsory advisory forum, someone had suggested. So before the court goes to the consumer court, it goes to some doctor, some forum which consists only of doctors and they give an opinion. Such opinion is compulsory as far as criminal cases are concerned. Jacob Matthews case says that no, before the court proceeds in a criminal matter, it has to obviously take opinion.
In the present scenario, can that be applied to the consumer?
No, it's only in criminal cases, as good as that. So an amendment will have to be brought into. That is, if I understand, the suggestion which had come out was something on that line.
It should be focused on the doctor-patient relationship also, sir.
Okay, yes, sir. I'll speak on it. We have that in the plenary session at 2 o'clock. That would be there. Sir had very briefly stated on tort reforms, no fault compensation scheme.
So now these are the new inventions which are being done in other countries. No fault compensation scheme to a certain extent has given good results in New Zealand. So there what happens? Patient undergoes treatment and they have a schedule of fees. Eyes lost, cataract surgery. You will get 50,000 rupees, that's all. The advantage that ought to have come out of it, but again there is some dispute on that.
That is a public funding mechanism.
Yeah, so no, that is fine. So
There's a cap with the.
no, not cap. No,
not
cap. No, it's defined. It's free.
The fund is by the government. If
The
there is
treatment
a
is something like NHS.
Yeah.
Everyone has to go to this but in tort reform there is an alternative where actually the government funds so if this Prime Minister's scheme comes into existence, then perhaps that could be implemented. So in the no fault compensation scheme, courts don't ask you whether the doctor was right or wrong. But the purpose of bringing the no fault compensation scheme was adverse event reporting. That is not happening. The whole idea was brought into existence that doctors should be reporting whenever some adverse incident happens so that corrective measures can be taken. Rather than that, doctors try to put it under the carpet. But that is not happening. So that is one more option that is available today. Sir, you had a question.
The patient who pays and who does
Okay,
not pay.
so patient's payment.
There's an analogy here. Business class people are compensated more than the economic class.
Question is different.
Yeah, my
sir.
question-
In
They
GH,
restitution in
they
integra.
they don't pay.
They
GH
don't pay,
doesn't
so they don't come under medical negligence in the government hospital. The government hospital doctors,
Yeah.
they don't come under consumer protection because same amount of medical negligence, what.
But you can go to civil court and.
Civil
Court,
code.
they can, but not the consumer, the consumer.
But in certain
Now it is
cases
changed,
in
sir. For
Delhi.
government doctors also they find
Yes.
nowadays.
Yeah.
Other than that, if it is not a secret, can you tell me, sir, how advocates escape the consumer court?
Yeah, sir, that's a good sir.
So,
If you can share the secret, we will.
Law is more uncertain than medicine.
so this is what is professional prejudice. It happens in medical council. So doctors don't go against doctors and perhaps it is happening there. in the
When
Supreme
cases
Court.
are lost, just because.
Professional prejudice, as good as.
How you
You
allocate
can
it?
consider also Medical Injury Tort Compensation Reform Act, which is already in existence in different states.
So if you could, where?
Sir, US, for example, you can see California's Medical Injury Tort Compensation Reform Act, which has two segments. One, there is a capping, then there is hybrid case where people try to sneak out.
Very
capping.
recently reported.
Yeah, very recently, 2 weeks, 2 days or 2 days. Hybrid cases have been coming up, so something on that model. Sir, capping is there, sir.
Capping, okay.
Yes, sir.
But
there
capping
is-
of compensation.
No, that is okay. Hybrid.
The hybrid cases, they use a partially of this case. So selective usage of the claims. They use whichever, say this much compensation can be claimed in this, under this act. Plus they say this is negligent under this act, getting the best of the both.
Getting the best of both worlds.
Yeah.
No, but capping will not work in India.
Why?
Okay, so there is a reason behind this. In India, see, what is it that the US courts have capped? It is only the non-monetary compensation. I was stressed, I was under depression. Courts give you compensation even for that. Something that cannot be quantified. Okay. So there, that compensation is capped. But the actual loss that is caused to you, that cannot be capped. See, but 40 years of your productive life you have lost. So someone has to compensate who has done that. court wants to put you in that position back. So even in US, that compensation is not capped. It was that compensation which was been granted into millions and billions. But in India, the story is different. Even in that 12 crore compensation case, that was an American doctor.
Yeah.
He wanted 40 crore rupees as the other compensation. The court only gave him 5 lakh rupees.
Like under that head,
Under that head.
particular head, under that particular head.
Non-pecuniary damages. Okay, so a damage which cannot be quantified. Under that head, the court has given 5 lakh. In one case only, court has given 10 lakh, not be above that. So what are you going to cap? That 10 lakh. Court is not going to give above that. So in India, that won't work. Anyway, coming back to the topic.
But it's not, one more thing.
Yeah,
Product liability where,
1 month. On the tort reform, let us hear, sir. Yeah.
Power is not working. Power is not working.
Okay.
Sir, please.
So power is not working.
So not working at all.
Yes.
Okay.
So in the tort reform, there is a thing on the product liability. See where, say, if I supply implant, if that is not working well, not only the doctor is penalized, but I am also penalized in the tort reform.
Supplier and manufacturer.
And that is one of the disadvantages of the tort reform actually.
Okay.
So what happens is, people to go to innovation, they will hesitate now.
So friends, we generally have come to a broad consensus, I won't say a clear consensus, that yes, medical tribunal could be a way out, and certainly mediation, clinical establishment, an advisory panel consisting of doctor before the court could come to a conclusion. These are broad things that we have discussed. If we all could give one minute to summarize what is it that we think could be best going ahead. After that, we will summarize and we'll put this session to an end. Can we start
If I'm wrong, already this government has brought an amendment that doctors are away from the...
No.
It's not there.
That is not in the inclusion. Exclusion they have not put it.
They have not put exclusion, they ought to have put an exclusion. Because doctors have been included thanks to a judgment of the Supreme Court. Okay, so it has to be overruled. By VP Shantha has to be overruled. Yeah. Can we start from there?
The health sector comes under the consumer protection.
So can we start from there? Capping it in 1 minute. As from there we are going to start. Right, from that side. One by one we'll just cap.
Yeah, as I said beginning.
Look, please. I'm so sorry.
Yeah, as I said at the beginning, I think we need to have better understanding. It has to be more horizontal across the entire fraternity to come into the ambit. See, for example, being a medical director, I face certain specific challenges, though I don't want to quote it in a very raw sense, but then, for example, implementing consent forms, making doctors to understand the importance of consent forms and not taking it lightly and then try to argue on that. That's my point, because even simple things, it's not definitely simple, but then consent forms are very legal documents, but not many doctors would understand that, but then they take it lightly. So that it's just one example that I'm trying to quote. Similarly, there are a lot of things in a corporate hospital and also in the government sector. There must be a lot of other issues. So I think there has to be a forum which is kind of very cohesive, and then it has to go to the grassroots level, educate doctors right from the beginning to make them understand the importance of the legal implications of the medical practice more than the medical practice per se. That's better, because when I buy a car, I look at taking insurance, driving license, registrations. These are the prerequisites, and then I abide by the law that says for the road traffic. Similarly, when medical practices are coming, doctors needs to be educated appropriately at every level, be that be the beginning or till the fag end of their career. Then they have to be more open to learning the medical aspects of it, because it's not just that we are protecting ourselves, but it is the best interest of the public and best interest of the patients, because damage done to the patients are damage done to the society. And doctors are treated like, doctors are always treated like gods, now at times dogs, okay. So the doctors, when they are looked upon, as gods and other things. We need to be more sensible. I know Dr. Dr. Kishore agree with me that the importance that we have implemented extensively lot of documents in Global Hospital with his help, because he used to help me a lot in specifics. And the importance of being very inclusive about even languages. We are trying to say that one language, so just put the consent forms in English alone. Forgetting about Tamil or Hindi about all that. My point is, on a broad sense, being inclusive and being open to learning, and be the junior most level or to the senior most level. And someone said, very beautiful point of implementing the gateways, like a triage kind of system, and RMO sitting in every hospital to receive patients and then coordinate in and out of the services so that they have a better understanding. So all that I can talk. Thanks for the time. And my point is being open and inclusive. That's it. Thank you, sir.
Sir, you sir.
Sir, I will put forward my views. Here the patient is a consumer, the provider is a doctor. The friction comes because there is a lack of transparency from the provider and also the acceptance of the transparency by the consumer. Here, I feel that doctor is not coming from the another planet, because in this time we have given the opportunity to treat the patient in the way of through the medical system. That is all. Everyone like this, engineer treat dams and roads, and other fellow computer treat the computer. We are treating the living organism. That is why we are not different, we are not at all a god. That is absolute wrong concept actually. In fact, we are only the human being. Fortunately, we are treating the living organism. That is all. So, when the doctor is totally transparent, then no problem comes, one thing. Second thing, because of the increasing the advancement in the computer world, because of so many advancements keep on coming, doctor is not updating the knowledge. Second, when he updates the knowledge, there are problem solves. Third, he must come out with a transparent idea, what to be done, what not to be done, when to refer, when to not to refer. Tell me everything, what you know about the condition of the disease to the patient. That is very important. For example, when a patient comes to me, I will tell you everything what I know in the disease. Suppose a patient asks some other question, because I don't know this, I can refer you some other doctor to treat this. That is all simple. My problem is simple. The problem is lack of transparency. Lack of exposing ourselves, what is my level. That is only friction starts, sir. So, I will put it in a nutshell. Doctors should update the knowledge, then transparency. Moreover, any patient comes to you, make him as a friend, sir. Make him as a friend. Don't treat that he is a patient. Make him as a friend. You tell them that. So I have got an opportunity to treat you. Then make him as a friend. The problem comes, even the suppose adverse effect, the problem comes, he will not scold you. He will not find fault with you. That is another point. Doctors should learn the humanity. Because most of the time their humanity is lacking. That is what I want to stress. So make them as a friend, updating the knowledge, transparency, the friction doesn't erupt at all. If it comes as a friction, I will put forward, before going to the court, before going to another judiciary, higher officials, I will form the intermediate body, like a panchayat, like a appellate or ombudsman, whatever you can call it, where he can one be a selection of one advocate, or maybe a one doctor, or maybe a common people, or maybe a relatives, everything. They will settle the issues. See, doctors, he know very well the family physician role and everything. There itself settle the issues, no problems at all. So that is why I will tell you, make it life is a simple, make it life is less complicated, so that when we are transparent, nothing will come, sir. Thank you for the opportunity.
Well, sir, I think we are talking about what should be required, whether it is mediators, whether it is compulsory advisory forum, or whether it's an advisory panel. Definitely, there should be an advisory panel of experts to guide the legal team or whoever is the decision maker or the verdict giver to analyze and make an amicably acceptable decision on both, whether it is the patient who's affected or the service provider, whether it is an individual or whether it is an institute. Amicably acceptable to both. This advisory panel of experts will enable to put forth with whatever available resources at the time of service delivery was provided to the patient to deliver the best outcome of the need at that particular moment. This cannot be standardized because we are talking about different geography at all times. We are talking about different specialities. We are talking about different diagnoses. We are talking about different human beings. And the responses of the same medicine given to the same diagnosis will differ because, as already been said by many, that human beings are not standard. Everyone has got a different genetic composition, so the response would also differ. That is where there is utmost importance of the advisory panel to see, yes, whether you talk about a standardized practice, whether you talk about a protocol, whether it is a clinical protocol, whether it is outcome protocol, whatever it could be, whether it is the British formulary, whether it is the Indian formulary, or whether it is the American formulary, whatever is it, whether it was utilized or provided at the right time to the right patient as per the standard practice. So this kind of a expert support can be given only by the advisory panel, which will make a big difference in passing on the final judgment to the care seeker. Wherein again, like, there would be no space to any third party agency or the media to play a foul game here. That is what my opinion is. Thank you.